the purpose of this panel is really to talk about our study titled 2022 Construction Adjudication in the United Kingdom, Tracing Trends and Guiding Reforms. We already had a session on this report in Edinburgh at the Adjudication Society conference, where there was a lively and interesting debate. There are copies of the report. I mean, some of you have it already at the back of the room. And I'll share this panel with Kathy Gall and Hamish Lal, who have been members, are members actually, because the project is meant to last for 3 years at least, are members of the steering committee of this project. Kathy Gall is a chartered architect, and she continues practicing as an architect, but also since 1998 she has been a dispute resolver, and particularly in adjudication. And he brings, therefore, has brought a huge experience to the project, and it brings a huge experience to the panel. And Dr. Hamish Lal is a partner at Akin, Gump, Strauss, Hauer and Feld in London. He's a solicitor advocate, therefore with rights of audience before all the higher courts in England and Wales, and also admitted at DIFIC in Dubai. And I think has been the first lawyer who, at the same time, is the chairman of the Adjudication Society and the Society of Construction Law. So I'll introduce the project briefly, and then I'll try and talk about all the non-controversial bits, and then I'll hand over to Kathy and then to Hamish for the more interesting and perhaps to an extent controversial stuff. So this project is a part of a partnership really with the Adjudication Society, of which Hamish is the chair. We are very grateful, and we work very closely with the steering committee. The other members are Jonathan Cope, Claire King, Lynn McCafferty, and James Pickavans. And while the authors of the reports are Alexander Kalish, Research Associate in Dispute Resolution at King's, and myself, the contributions of the steering committee, and indeed beyond, other members of the Adjudication Society have been really fundamental to achieve what we have. Now, in the foreword by Lord Justice Colson, he says he believes this is going to be a seminal moment in the history of adjudication. I don't know, we shall see. I think history will judge. I think it's appropriate to say. But what we have done is, of course, to build on previous work by the Adjudication Society, which started in 1998 in terms of collecting raw data and quantitative data on adjudication, and we did it in a consistent way so the data was comparable. But we also expanded the scope of the research that the Adjudication Society had done in the past, asking many more questions of individual practitioners and adjudicators about how adjudication actually is working in practice. There were 2 questionnaires, one addressed to adjudicator nominating bodies, and 10 of them replied, all the most important ones, as you can see, including RICS, RIBA, TechBar, TEXA, UK adjudicators, and others, ICE, obviously, and 257 individuals, of which 44 practiced exclusively or absolutely predominantly as adjudicators. There were 89 questions in total. In terms of the breakdown of respondents, almost equal numbers of quantity surveyors and lawyers, although quantity surveyors, I have to say, beat lawyers by 1% on this occasion. There is in the report an appendix. I'm not going to talk about that too much, on the methodology and particularly the breakdown of places of practice of respondents, of individual respondents, which I'm pleased to say were predominantly 50% in London and the Southeast region, but all regions in the UK were represented. A wide range of seniority. Over 40% of respondents experienced at least 50 adjudications or more. And of course, those who experience fewer than 50 adjudications, it doesn't mean they are not very experienced construction lawyers. I would say people like Alex and myself, we probably predominantly do arbitration, but we are more and more interested in adjudication as well, obviously. Now, let me move away from methodology and look at the raw data, the data from ANBs. I mean, first of all, we asked about the number of adjudicator appointments made without the involvement of an ANB, and not surprisingly, you have the breakdown of the numbers, you have the reports. I'm not going through those figures, but there are few appointments that do not go through a ANB. There are, however, some. I mean, it's not the number is not zero or close to zero. One piece of information that we ask for of ANBs is the number of received adjudication referrals leading to nomination. And we covered 2 years because there was 1 year gap in the previous Adjudication Society data, but going forward then data will be yearly data. And as you can see, the total number of referrals, and in particular, I look at the year ending April 2021, was extremely high. It's actually the highest number on the record, even if a few ANBs did not respond to this particular questionnaire, so the number is likely to be even higher. And the 2022 number is still quite high, 1,900 plus. And as you can see here on the graph, we plotted the increase in numbers of adjudication referrals to ANBs from the very beginning. And then you can see that although there is, after the peak of 2021, there is a slight drop, these are still very high numbers, and these numbers have been increasing steadily over time. We were interested in whether COVID had made any difference on these numbers. The numbers themselves do not show any significant, let's say, structural shock in the data. You don't see a big peak, you don't see a big drop at the time of COVID or shortly after. And we also ask a qualitative question of individual respondents, the majority of whom actually said that 38% of questionnaire respondents said that COVID-19 made no difference to the number of adjudications. 30% said it increased the number of disputes at least slightly, and 10% said that it decreased at least slightly the number of adjudications. Probably what we can conclude from that is that the impact was not material or particularly material in terms of COVID. Again, in terms of raw data, number of adjudicators relatively stable since 2016, adjudicators on ANB's panels. ANB's fees is boring and I'll skip it, it's in the report. They are broadly comparable and not very expensive compared to the overall costs anyway. It's interesting, however, to look at here at trends in terms of disputes and in terms of adjudicated disputes. The most frequent value, as you can see from the graph, I don't know whether the slide is clear enough, otherwise you have the report. The most frequent value was between 125,000 and 500,000. However, it's also clear that adjudication is used for claims that are much more valuable than that. 60% of questionnaire respondents said that they typically see value of adjudicated claims above 1 million. And if you consider that an adjudication, although there has been, as you know, a kind of complex case law on what is a dispute, etc. Certainly you cannot do, as you do in a construction arbitration, bundling lots of claims and counterclaims that clearly pushes the value up. So they're relatively high values. Now, in relation to causes of disputes, that's a slide that has captured quite a lot of commentary and discussion in Edinburgh and on a number of other seminars and discussions about this report. We asked what are the leading causes of disputes that people have seen, practitioners have seen in adjudication. So it's not causes of disputes in construction generally, although you can, given that most disputes in the UK, of course, are adjudicated, you can make a clear correlation there. And you will see that the leading cause of adjudicated disputes in inadequate contract administration. I think that very much resonates with what John Aff said earlier today, followed by, this is I think no surprise to anybody, changes by client, exaggerated claims, at 43%, and 41% lack of competence of project participants, which is actually quite close in a sense, or linked to poor contract administration. Then you have many other actual causes of disputes that then follow. The final slide I'm going to deal with is in terms of time. Again, this is one of the perhaps non-controversial ones. Only a minority of cases are concluded within 28 days, but the majority of cases are concluded between 29 and 42 days. And what drives the time is not really the value, but rather the complexity of the dispute. So I said I would deal with all the non-controversial stuff. Then for the interesting stuff, I hand over to Catherine.
That sounds like provocation to me. I'm not sure I'm going to be very provocative about these things, but some of the things that were uncovered and are set out in the report are extremely interesting and some very surprising. This part of the report turned to effectiveness and fairness of proceedings. You might show me yeah, okay, thanks. And I'm going to paraphrase Sir Peter Coulson here, who identified 3 characteristics associated with an adjudicator, and I presume a good adjudicator. So it's time management, the ability to manage the time given that it's so constrained, and using timetables to do that. The ability to grasp essential issues and not to be distracted by not such important issues or deliberate insertions of information that aren't relevant. And finally, the ability to treat people and the parties fairly and courteously and pay due attention to the submission of documents or the documents that have been submitted. And so the questions that were asked related to the minimum standards that adjudicators should meet before appointment. Notice that the question doesn't say before all appointments, it just talked about appointment. And unsurprisingly, perhaps the most positive response related to knowledge of construction law and adjudication, and you would imagine that that would be the case. And it's followed by competence of a relevant preparatory course and a qualification, and then minimum number of years and so on. And only a very, very small percentage of the respondents suggested that there were no minimum standards necessary at all, which is odd. One of the questions that might be useful to ask in the future could be, should adjudicators continue to undertake training to keep them up to date? Obviously, the CPD aspect of it is important. And it may be that it's embedded in a couple of those results, but I certainly know that a number of the ANB bodies require adjudicators to refresh their knowledge and demonstrate that. Thank you. So, turned next to effectiveness and fairness of proceedings. more widely and complaints about adjudicators, and it's good to hear that they're rather rare. The only sanctions that ANBs can actually provide or give are reprimands, suspensions, or possibly removal. And thankfully they are rare. So the table shows for the 2 years that Renato has mentioned, the ANBs reports on how many adjudicators were reported to them for some reason or other, and what was the result of their investigations. And it is low. Thank you. We'll talk about perception of bias or actual bias, and this leads into a different area of the report. So this part of the questions related to the frequency of adjudicators voluntarily disclosing information, facts or circumstances that might give rise, or at least the perception of bias in the eyes of the parties. And I think that result of, I think it's about 20-something% of most of the time is shocking, and rarely is quite good, but the most of the time, or sometimes, is shocking. Perhaps I shouldn't use such emotive language. Okay, but at least 40% of the questionnaire respondents suspected that adjudicators had demonstrated bias at least once. And it doesn't mean at least once in an adjudication, it means over the time that they have been adjudicating, but nonetheless. Adjudicator bias was suspected for a number of reasons, but actually when you interrogate those sort of questions, it seems to relate to the relationship of the adjudicators to the parties, whether that's a real relationship, a perceived relationship, or maybe history of a relationship, as in the adjudicator has been involved in one of their disputes previously, or they're known to the parties, or some other reason. I mean, the other circumstances there give rise to all sorts of possibilities, I think. But I thought that was an interesting point here, given that certainly in our discipline at REBA, we're always asked, if you have any conflict of interest, you mustn't take the case. And if you do know any of the parties, I think it is a very odd thing to do. So we generally don't do it, despite the provisions that allow a named adjudicator. Pulling that to an overall conclusion, and despite the perception of bias, of procedural fairness and so on, it's very gratifying to see that generally adjudication is perceived to be a fair process, and about just under 20% of respondents believe that adjudicators were always, the adjudication process was always fair, which is great. Never is quite a small percentage, but I wonder what was going on in those particular issues. Most of the time is also 80, well over, something over 80%. Thought that most of the time it's fair. Okay. Adjudicators apparently quite rarely request parties to produce specific documents, and you can see the spread across there. So about 10%, between 1 and 10% rarely ask, and only about 2% always ask. And we had some discussions earlier on about it, and I don't think I've ever come across a dispute that's been referred where specific documents haven't been asked for. So I'm quite surprised when I saw this particular result. Alex thought it was rather amusing that I always have to ask for the contract. He thought that was a given. Well, you might think it was a given, but apparently not. 60% of respondents said that the parties sometimes abuse the adjudication procedure for their strategic advantage. And you can see the graphic there, that most of the time about 20% thought that the parties abused the process, whether it was the timing of it or the mechanisms that they tried to adopt and so forth. So that's quite a large proportion. Turning to cost efficiency, there's a requirement under the scheme that adjudicators should avoid incurring unnecessary expense. And the questionnaire asked adjudicators and other ANBs to comment on what the most common steps were in order to meet this requirement. So the most common steps seem to be deciding cases on a documents-only basis rather than going in person or arranging meetings and so forth, limiting the time periods that's available for individual submissions, and working with electronic bundles. And I suspect even Renato mentioned about the effects of COVID, but I imagine that the way that COVID has made us operate has changed that statistic. So if we'd looked at that perhaps 5 years ago, we would have seen a slightly different shift and balance in those figures. Adjudicators typically spend between 40 and 56 hours on an adjudication. And that seemed to be irrespective of the type of claim, volume or whatever, the value. Adjudicators' median hourly rates fall between 251 and 300, and their median total fees charged turned out to be between 12,000 and 14,000. Going back to one of Renato's earlier slides about the types of dispute and the value of disputes, I think I'm right that about 20% of referrals related to disputes that were around something like £50,000 or between £50,000 and £100,000. So it's quite low value disputes. And certainly one of the issues that has arisen is how much adjudicators charge in relation to low value disputes. I'm not suggesting that there should be a correlation, but it is an interesting area, particularly with very low value disputes. Questionnaire respondents often said that technology helps to foster the time management and the dispute management of the proceedings, and to simplify the procedure. So use of electronic bundles or digital information is much, much more commonplace, not just written stuff, but photographic, video, all the rest of it. So that has also become very much more used, I think. There is an issue about cybersecurity and almost not turning to who might be interested in finding this information out in these sorts of proceedings. Some measures are evident to protect the security of information going between the parties. About just under half said that password-protected information was their preferred choice of dealing with these things, but about a third said no particular measures at all. Okay, so I'm going to ask Hamish. Carry on.
So this slide really looks at errors in adjudicators' decisions. It's interesting because a lot of people think naturally that the decision is correct, perhaps because they've prevailed. But there's a nice spread of people who do have concerns about whether the decision is legally or factually correct. Corrections, it's difficult because it's a time-sensitive process, so your decision's got to be reached and delivered within 28 or 42 days. So the scope for corrections is small, but this is what this slide is just telling us is what we already know, typical sort of slip rule type corrections, nothing substantive. This is perhaps for me one of the most interesting bits of the research, whether decisions ought to be summarized and published or put somewhere so that all of us can see how that particular issue was decided in adjudication. We'll see how this question pans out next year, but a lot of people, 30%, think that with redaction, they should be published. And personally, I think it would be good if they were published, because in my experience, a lot of decisions are total rubbish. And I don't mean that in a negative, I mean in the sense that they're legally incorrect and factually wrong, but they're still enforceable. And I hope that redaction and publication might bring some consistency and stop some adjudicators just banging out whatever they want, knowing that it'll never, ever be ventilated. But this is something that the Society is looking at over the next couple of years to see whether we can address it. Enforcement, I mean, this is really an analytical piece of work that King's have done by looking at the TCC decisions that have gone as far as enforcement to see what sort of issues come up. We all know that the TCC judges will enforce decisions unless something has gone wrong. Interestingly, one of the judges in Scotland made an observation that this whole area could have been fundamentally different if the Act had allowed for setting aside of a decision if it was clearly or manifestly or significantly wrong. Whereas all of the TCC jurisprudence is, as long as you stay within jurisdiction, it's enforceable. Again, whether that is picked up in subsequent reforms is something for development. These questions around insolvency and adjudication, it's pretty obvious. Everybody who's dealt with adjudications recently will know that parties, even if they're insolvent, can bring a claim. The question is all about enforcement. Should you do it? But what the data is showing is that insolvency is not preventing people from raising adjudications. And again, same slide. It's just giving us a bit more data on whether you're a respondent or referring party. For a lot of people, the question of diversity in adjudication is really compelling. The data appears to suggest that less than 8% of all of the adjudicators listed on the 8 nominating bodies are female. My own feeling is that figure is probably a lot lower because there's a lot of adjudicators that are listed twice or 3 times or 4 times in different panels. But this figure should make everybody sit up and think, shit, what is going on? And I picked that word deliberately to make people remember hearing it. This is a problem that needs to be fixed. And I think everybody wants to say, yeah, we'll fix it. The question is when, not so much how. And the Adjudication Society is in the process of fixing it. And you'll hear more from people like Claire King and Morwenna Crichton in January as to exactly how this issue will be tackled. It isn't good enough for adjudicators to say, there's nothing wrong, it's a great process. The panels are full, everything is wonderful. Patently, there's a problem. Nearly 60% of the lawyers in my firm are female. 50% of High Court judges are female. So how can we have such a low percentage of decision-making in statutory adjudication? So this is something to look out for in very early January. We haven't even spoken about the other issues dealing with diversity. Just focusing on the gender point is shocking enough. Again, this slide was interesting because when potential solutions are sort of articulated, we get a slightly odd reaction. Clearly there's a problem, but look how small the constituency is for people saying, let's have a public pledge akin to the arbitration pledge. Something like 4% of people think that that's not a good idea. Well, it's worked in arbitration, so why can't it work in adjudication? What if all of the main contractors, all the main consultants said, we sign up to this pledge, we want a female adjudicator, at least 1 out of 3 times? That might move the dial. But all of these issues as to how to improve it will be looked at very methodically by the Adjudication Society, working very closely with Professor Nazzini's team here at King's. And I think we're now going to reform.
Yes, and just very briefly to conclude, we asked a final question of respondents. What do you think should be changed in the regime? And of course, you asked 270 adjudication practitioners, and you get 1,000 different views, and many of them driven by the last case, and one wins or loses or whatever. But certainly two themes emerged quite significantly. One is the justification for the exclusions and the residential occupier exception, whether this should be thought through again, reconsidered based on evidence, based on analysis. We are not reaching any conclusions here. I'm just saying what the themes that emerged powerfully. And the other one is the payment system, the system of notices, and giving rise to smash and grab adjudication. That was clearly perceived as something complex. Duplicative adjudications are never, or duplicative litigation or arbitration is never something to aspire to. Now, quite how to solve it, it's an issue for another day. Maybe in the next report, we will focus a bit more specifically, indeed, now that we know what the themes are on reforms. But we are also planning on having a workshop for feedback on the report and feedback on what we should do next year and in 2 years' time. So there will be plenty of opportunity for those interested to discuss all of this. We have perhaps time for, again, as usual, 2 questions before Professor Mosey takes over. And please, Sean, there is a question there. Microphone, please. And let me check online as well.
Sean Gibbs from UK Adjudicators. I founded UK Adjudicators 5 years ago, and we've been open for panel applications since then, and we've been encouraging people to apply, and we're finding that women aren't applying to our panel in the numbers that we want, and so many other people who are underrepresented aren't applying. How can we encourage people to apply to panels that are open? I'm not talking about the closed shop panels, which we all know of, and they've been doing the same practice for 20 years. But, you know, if there are panels that are open, how can we let people know about it, and how do we get them to apply?
Yeah.
I'm not sure, Sean, if the problem is applications or whether there's a gateway way before that needs to be first addressed. I think it's a sophisticated topic, and we can't really unpack it here in the question. But just watch this space, because the team has been working on it, and in January, the whole sort of initiatives will be unpacked. I think it starts with training, encouraging, but also mentoring, but also showing people that a diverse decision-making panel, if that's the right phrase, is achievable. I think there are a lot of fear factors for younger solicitors, barristers, and QSs and so on from thinking they can do it.
Thank you very much.
Can I add
Kathy, yes, please.
a quick point? I think it may also relate to the discipline that the individuals are from. I'm an architect, and in my discipline there is a lot of discrimination still. From starting university, where courses are 50%, the number of women in architecture is terrifyingly small, and that's a separate subject, and I'm not, waving a flag for any particular thing at all. But given that in that profession, people who might be interested in this area there's a small group to start off with, and then there are other issues that are clearly coming into play that will deter women from applying. But it's great to hear that your panel is open.
Thank you. I think we don't have time for any more questions on this. But I have to emphasize, I mean, the question was about diversity. We will, as Hamish said, we are looking forward to taking some initiatives and engaging more on this in January with the Adjudication Society. So thank you very much to Hamish and Kathy for being here this afternoon.